Ebusia phone etie for ni de kwan so me ma obi bia akwaba ba channel so han a daily update ebusia court case update na ye de bremo no nanse ya the presidency enya petition bia na seeking the removal of the chief justice Tokoono say or so far no nedwuma onye fit say obe occupy as a position no president nya sa petition no ana opie ba bontin through ne government Minister of Government, Government Communication, Felix Ofusu-Kwakye Pieba Bontembe, Ghanaians who say the presidency ni any petition be a seeking the removal of the Chief Justice. Ntino said the Mrane City no Oma for the Akroma, the Council of State. Eba sa no so utimu said some NPP MPs bini NPP lawyers be a bit back when Ekuasefua Otafo MP Echo Supreme Court Echo file injunction e mo kire say e wo say a president ni Emma Chief Justice ni hearing nti omukọ court I think say after eno na the Chief Justice nso pie ba bonten ebe ka ne nsem na o ka ne nsem na the president no President of the Republic of Ghana, His Excellency John Dramani Mahama, a man who said 10 days. After all, the Chief Justice was seeking 7 days, but the president in a man 10 days so on responding or responding to the president in GCC and a Wednesday it was expected say court ebet nas no medi make us injunction na and as application na ekuasefua through the lawyer Godfred Dame or the court say omo because omo prohibit president ni say obetimi kura continue sa process ni so obeyi chief justice no efro na ebusia ene omo court no entimi antna asem no so because the attorney general the attorney general Dominic Akrutinga Ayini etro koma court ne say there be omo ye workshop bi enti that is the judicial or non side no omo ye workshop nti workshop no omo ya ama ne nkofo enti no mu ntimi emba court. And that was even so. Yes, so many country koma Supreme Court from Bayer 7th or more let's say 7th to 10th of Samanti on workshop be ama on no call for our afe na wafa omo ye meeting went me anko court ama court no as suspend and as wa adjourn indefinitely sini die said the abangbabin ye no our adjourn parliamentary proceeding sini die no Supreme Court and so atna say adjourn sa case no sini die until say that is indefinitely until say kasa be pie ba bontan be kasa okay you say you betima tena asem no so no sa asem no sisi no bibi say no sisi and we don't know the fate of Chief Justice Tokoono na sa case crown from where I sit I see it to be a moot case because already no more say wa money hearing. That was the application was say the presidency ama Chief Justice ni hearing into a money hearing there hwe na man here the ant was and the president and as a presidency so ama Chief Justice ni hearing ama Chief Justice na responded into akwaya say o case no kra na what dey ba say ye determine say president no ye and as one ye no already no kra no president na ye into from where I sit and I see it to be mute but until say the court ebe pie ba bonten edict or more ruling ebeba no na court no ruling na eno na ebegina but from where I sit in sana me hunu me nka say sanity I cannot be prejudiced ntino sana me de me hunu nje busua Martin Pegun so pia ba bontin de nsem bia betuja regarding to sa issue we nyina me ma me kasa nyetenti e beko ne akotie nsem ne nchire mu Nyankopon hira ye nyina me da se bebre.
And the Council of State to establish a prima facie in order to kickstart the process of removal of the Chief Justice from office. Interestingly, the much awaited and highly anticipated hearing of the application was scheduled for this morning. However, it became apparent in court that indeed the Attorney General, who is the respondent in this case for government, has written to the court to inform the court that the department is in a training or a form of training and therefore should be exempted from all court processes. We had the immediate past Attorney General who is representing the plaintiff in this matter, the Honorable Godfred Dame, speaking to the press not too long ago, and he was asked questions in with regards to whether it's an attempt to stop the consultative process for this particular application. And he profoundly mentioned that the law has a way of exposing the intent and the hearts of men. And so, as far as they're concerned, they only pray the court for a true meaning. I'll bring on my colleague Barbara Kuma to join me to help us make meaning of some of the things that went on in court this morning. Thank you very much, Barbara, for joining us. Barbara, you had the privilege of sitting in that courtroom. What actually went?
Like you explained to our viewers, expectations were high for this case, and we know that we saw this particular matter for some days now. So we were expecting that today was going to be a showdown in the Supreme Court, and we had the application of the injunction, motion for injunction, and all that. But I mean, when it came to court, first thing we observed was that the AG seat was empty. Mm-hmm. That was the first thing we observed. Mm. And then we kept, then rumors kept swelling in the courtroom that the case is likely not to come up because the AG's department, there were no people occupying the seat and so we kept faith in the seat and all that. So we kept faith. We were like, okay, let's see what will happen. And then the case is called. And then the panel said that the AG had written to the Chief Justice that they, from the 7th to 10th of this month, they were occupied. There was a training going off for the state attorneys, and so all cases that were for the AG's department was supposed to be on hold until after the training. So basically, that's what happened. But then the plaintiff's lawyers were not too excited about this development because they thought that even if there was a training of that sort going on, I mean, the AG, this is a constitutional matter that, I mean, according to him, holds some gravity. And so the AG should have at least considered that and been in court for the matter. But however, he was not in court. But what was interesting was that the AG sent state attorneys who were supposed to be in the training to court to come and say that we are not coming to court. And so the court adjourned the case.
On that particular subject, or on that particular question, Godfrey Deboadame, the plaintiff's lawyer, on the stairs of the Supreme Court, made a very interesting statement that given that attitude, it amounts to the AG not intending to give the application a certain hearing in court. Lawyers and the law have a way of exposing itself. Indeed, he mentioned that the law has a way of exposing the hearts and the intents of men. Now, this is what we know currently. Do we know whether this will be recalled in the shortest possible time or that it has been adjourned to a different date?
Well, fortunately, the courts talked about it and said that since the letter had been approved by the CJ, it was not proper for the panel to fix a new date for it until what the situation was with the AG's department was settled, and then maybe the CJ, fix a new date for it. So the case has been adjourned indefinitely, or sine die, as they say in court, until another time when it is rescheduled for hearing. But definitely it will come off.
How will that affect the consultative process? Because the whole point of this application, some will argue, is intended to stop the consultative process between the presidency and the Council of State. And so how likely or how will this adjournment sine die affect the consultative process?
Well, to the lay person, it probably wouldn't affect it. The consultative process would go on, perhaps, but if you heard what the plaintiff's lawyer said, because the substantive suit is in court, it is tried law that the presidency has to hold on until the final determination of the substantive case itself. And so the fact that the injunction suit didn't come off doesn't mean that they can go ahead or continue with the consultative process or whatever. But then the presidency is enjoined by law to hold on until the final determination of the substantive suit, which is yet to be called by the Supreme Court.
Well, Barbara, I am not sure whether you know, as part of this application, there was also an interlocutory application, injunction application filed. I'm not sure if it was granted. Do we know if it was granted?
No, that was what we were supposed to hear today. It says substantive matter, there's not been a date set for it yet, but the injunction is what was supposed to have been heard this morning. That couldn't come off because of the training going on for the AG's department.
Well, will that be safe then to assume that, given that it was not heard, it may be considered not filed at all?
No, that is not it.
Thank you very much. And so that's my colleague Barbara Kuma, who's joined me, events and proceedings from the Supreme Court of the Republic. As you heard, the application has been adjourned sine die. And so until we hear from the Supreme Court's registrar to say this day or that day has been rescheduled for the hearing of the application, we wait to hear what the two parties involved in this matter will do. Keep watching GBC.
And lawyer Martin Pebo is joining us on the telephone. It's Private Legal Practitioner Council. Good evening. Thank you so much for joining us here on Hot Edition.
You're welcome, Mr. Council.
Perfect. Now, so after this news of the Chief Justice submitting her response to the President following these 3 petitions seeking her removal, what next after today?
Yeah, so it means that now the President would be able to go into the matter, that's to determine if the allegations are serious enough and there is a bit of evidence, and say a bit, so that's to say that it doesn't have to be all the evidence at this stage, because remember it is a paper, so you can't, there is a limit to how much evidence you can put into writing. Some of it you have to bring physically, pictures, audio, video, etc. Right? So at this stage, the President is supposed to look at the petition, look at the answer, that's the Chief Justice response, then seek the advice of the Council of State and come to a determination. But usually when we say prima facie, we should understand that it's a complex way to explain, but speaking it simply, that's why I said a bit of the evidence, but it shouldn't be so low that anybody can just make any allegation and to pass through. But what also should be clear is that the petition should not, it's not possible for it to prove the case 100%. You see, so let's say, if in the petition, maybe the petitioner is alleging, let's say the petitioner is alleging that he saw Mr. Okanse is CJ, and the petition is against Mr. Okanse. Then he said that he saw Mr. Okanse and Dennis Puabiri having tete-a-tete right after a case in which Dennis Puabiri is plaintiff and let's say Beatrice is defendant in the Supreme Court. I may leave out appellant to those things, but let's just say that Dennis Puabiri and Beatrice are parties in the case before the Supreme Court, and Okanse is Chief Justice. And afterwards, saw Dennis Puabiri and Chief Justice having dinner and so many other things. He has eyewitnesses, etc. At the prima facie determination case, you can't ordinarily, you would say he should bring all his witnesses to come and do prima facie. No. But he says he will present so and so witnesses, etc. It means that it will be at the tribunal stage, all right? So it's such an allegation would most likely cross, okay, because it's alleging serious matters of ex parte communications and things about impropriety. So the point I was making is that you can't put the evidence, the witnesses. You've stated that you call them at the appropriate stage. So the prima facie determination, your case cannot be thrown out because there is no forum for you to bring the witnesses to the prima facie. If you are asked to bring witnesses to the prima facie stage, then it's like that will be a full hearing even before we get to the proper hearing. And so I'm just making the point that prima facie is a complex word, very varied. The meaning will vary from one example to the other. So generally, the way to look at it is that the allegations look serious, the person looks serious to prove them, generally, and they are within the constitutional limits, it will pass. Then when it gets to the committee stage, that the 2 justices of the Supreme Court and 3 lay people, that they are not lawyers, they are not MPs, they are not ministers, those 3 people, then they will now sit down and go into the case. Then witnesses will be called. They, as judges of the case, are also allowed to ask questions as they wish, because it's an inquiry. It's not limited to the court system where it's just adversarial.
Yeah.
This one is an inquiry, so they can ask as many questions to try to investigate the matter as much as possible. So that's where we'll go to if the petition and the allegations look serious enough. But if they don't look serious enough and the Chief Justice's answer everything, clear all the doubts, then the petitions will be dismissed.
See, that's some good detail and basic explanation, at least, for our listeners to follow every step of the way. So essentially, does a submission now lead to, or possibly lead to, the determination whether a committee will be established to investigate the allegations against the Chief Justice?
Absolutely. So it's at the end of it. If the President makes a determination with the advice of the Council of State that the case is serious enough, prima facie has been met, then that's when the committee will be set up. But also by the President with the advice of the Council of State. But if he makes a determination that, the allegations are just wild allegations, they are not within the law and they are frivolous, etc., then he will dismiss it. And so that will be the end of the process. Like what President Kufuor did when Professor Kufuor presented a petition against the Chief Justice.
Now, the other question that Dennis was asking, and it's been on the minds of many, is what happens to the court suit. In fact, the suit in court filed by the Otafo MP, that's Vincent Assefuwa, challenging the legality of the president initiating the removal of the Chief Justice, and then also one other Ghanaian, Ebenezer Owusu, also asking for an injunction on this entire process, because at the time the Chief Justice had not been contacted. Now the Chief Justice has been contacted. She's giving her response. Does that render these 2 suits mute that will be heard on Wednesday?
No, it doesn't render them mute, but it's also the muteness doesn't also come in because, okay, let's put it this way, let me rephrase. It doesn't render the suits mute. The court can go on and determine. But the Supreme Court is very clear that they don't likely injunct a public officer. So remember the e-levy matter, the suit was pending before the Supreme Court, and GRA went ahead. Remember the e-levy matter? Yes, the suit was pending in the Supreme Court, and the GRA went ahead with the implementation because it was clear to us that we said, hey, no. If you injunct the GRA, etc., the economy will collapse. We needed all the money from the e-levy to create jobs. So you see all the things that were promised, that there will be millions of jobs to be created from the e-levy, all the rosy things that were said about the e-levy, because we all needed that to happen. It was clear that a lawsuit to stop this will cause too much trouble. That's just one example. There are many other ones. So because of this, that when it comes to a public officer, some, not everyone, there are a certain class generally that if you stop them, the public will suffer too much. There will be irreparable harm. Generally, the Supreme Court doesn't stop them, so they continue with their actions even when the matter is pending. So more or less, that's the court makes an exception. Okay, that's why they say to every rule there's an exception. To every rule that when there's a case in court, stop, so that the court will finish deliberating before you continue. There's an exception. And that's one of them, that the president has a constitutional duty to perform at this time, that the process should go on. So you don't likely injunct. They don't. You know, as I said, it varies from case to case. Another case will come, though it's a constitutional duty, when the majority of Ghanaians get up and voice their anger, disgust, and sense of this and feeling that it's injustice, that public officer will stop. So a lot of these things too is the public, the participation of the public, the posture of the citizens also helps. When many people are very angry about it and they think the president should stop, he will stop. But where there isn't enough, like a critical mass of people asking the president to stop, generally it will continue unless he himself just says, listen, I'm just stopping. Sometimes they do. You remember when Professor Tokoono sued that he didn't want the constitutional review process to go on. After they were done and they said, while the case was pending, while they were trying to do the constitutional review, and then he went to court. That's the implementation stage. So he went to court. So President Mahama had to stop the implementation. The committee didn't have to wait. They had to wait for the case to be dealt with. And by the time they were done, there wasn't much time. And then the president lost elections, etc. So sometimes the president can stop, but other times, depending on the circumstances, they will continue. So we take it on a case by case.
We'll see how daily update TV. When you're in seminary, said the court update in a court, as he said, Chief Justice Nelson indefinitely. But as to say, out here other school of thought, how much let's say the law says, because the substantive matter and kasa court na court ni determine any kwan say or any kwan say the president in a and I mean a continue process of which utie the correspondent GBC for correspondent na oka obana or musa. But this same issue regarding to IGP Dampare media, yes, I'm not a lawyer, but case is about because kai IGP Dampare the say ya nkofo court file say any kwan say omoye de omoyi IGP Dampare free her because the substantive matter no enye determine wie ye Emma NPP bloggers pay by Bonte Becky can say maybe regarding to that issue. Yet the president it me so it me to us so it me the IGP Dampare every ho. And as to say, he see an court ama wa journey indefinitely on that case winning, silly dying on that case winning. Yenim say president needs a bet was on so on to us. Because due to ABC, you find make say the IGP Dampare no na or a judicial staffer, and I say no omoka the judiciary no. But share the Chief Justice no dia ono ne sorry mon fan me Osha IGP now no ka the executive the executive staffers no ka because the Ghana Police IGP omu part of the executives but Osha Chief Justice Tokoono on judicial on aspect that is the judicial organ of government of which I don't know. I can't really tell. Says how to me now, President Ninya even crossed when the case was pending. The substantive matter was pending at court. Still, Krana with me to me IGP fraud. You so when so the same thing meet matter also there. Lawyers and also more legal knowledge regarding to that issue with me part bit more them comment comment section on more educating any some of your viewers Yakupon shy na onye kese busia ye den common be stay tuned for more update the BCB yes had be come here that's